Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. On the 21st of March, in a filing that was released to the public yesterday, March 24th, the state of Idaho filed its reply to the defendant's objection to state's notice of intent to use IRE, that is an Idaho Rule of Evidence, number 404B. It says here the state has given notice of its intent to present evidence of an August 21st, 2022 contact between Latah County Sheriff's Deputy Darren Duke and the defendant, and that is Mr. Koberger. This contact occurred as the result of Deputy Duke conducting a traffic stop, and this traffic stop has been mysterious to certain individuals who have wondered, why did Deputy Duke even stop Mr. Koberger that night? There have been all sorts of theories that have been floating around, and we learn here from the state of Idaho what their position is for this stop. It says here, this was a result of Deputy Duke's conducting a traffic stop on a vehicle that was exceeding the posted speed limit. The driver of the vehicle was the defendant, Brian Kohberger, and during the course of this contact, Mr. Koberger provided the following information to Deputy Duke: his name, his date of birth, his address, and this was the Northeast Valley Road address in Pullman that he provided, and also his telephone number. Deputy Duke also identified the defendant's Hyundai Elantra and license and registration. And although Mr. Koberger was stopped for exceeding the posted speed limit, Deputy Duke elected to only issue an infraction citation for failing to use his seatbelt. And then the state alleges that the purpose of the state's offering this evidence is to prove Mr. Kohberger's admission and acknowledgement as to his identity, address, phone, and vehicle. The state is not asserting that the reason for the stop, in parentheses, exceeding the posted speed limit, end of parentheses, nor the defendant's failure to use his seatbelt are crimes or wrongs that prove his identity. Rather, the state is only offering the defendant's admissions and acknowledgments of his identity, address, phone number, and vehicle ownership. The defense was asserting that this was an improper use of evidence, that the state was trying to prove bad character by seeking to have this evidence admitted into the case, and therefore it should not be admitted. And here we see what the state's reply brief counters that argument contained in the defense's response. The state continues, in his objection to this evidence, the defendant conflates the use of 404B evidence to infer identity based on prior conduct similar to the charged offense with direct evidence of the defendant's identity. A traffic stop for speeding and a citation for failing to use his seatbelt have no connection, according to the state, to the offenses charged in this case. He is, of course, deemed innocent under the eyes of the law until or unless he is either adjudicated guilty at trial or he pleads guilty. The cases cited by the defendant all deal with efforts by the prosecution to offer evidence of prior criminal acts for the purpose of proving that the defendant committed the acts charged in the instant case. As such, those cases are inapplicable to the purpose of the state's offer of this evidence. And so they argue that the court should not disallow it on the grounds that it is improper character evidence. This will now conclude this episode of the Indie Zone. My name's Kathy. Thank you for joining us here today.